had to point and deploy a taser. And that another officer had to point their pistol at a defendant. An eyewitness saw the defendant shove the victim while near the police station. An RNO causing injury that was so severe that the officer is actually seeking specialized medical treatment from an orthopedic surgeon.
I didn't ask that, Ms. Gaines. I did not ask that.
Yes, sir.
Was the taser deployed?
I just don't think she's going to do what anybody asked her to do.
Mr. Bond.
Your Honor, we are just looking to address the condition of bond that requires that Mr. Hopkins be on house arrest. Prior to this matter, Mr. Hopkins was employed as a result of having the tether plates. No longer able to, in this case, he was no longer able to maintain that employment. He is hoping to be able to get new employment and is asking that the court consider a no go-to order, a no contact order, or anything of that nature. My client, Mr. Hopkins, also recently registered for the cybersecurity program. Text me that information. I tried to send the confirmation to Ms. Barroso so that she would be able to see it. It's my understanding that the classes are majority online, but that would be the only place that he would have to come across Chenal County. Otherwise, he's...
The courtroom grows tense as the prosecutor describes the incident. The defendant, Hopkins, allegedly assaulted a victim near the police station, prompting officers to intervene. One officer deployed a taser, another drew a firearm, and an officer was seriously injured, now seeking specialized medical care. Defense tries to argue for lifting house arrest so Hopkins can attend online cybersecurity classes and seek employment, stressing his lack of prior criminal history and that he's here with his father. The prosecutor and judge push back hard, emphasizing the severity, multiple resisting and obstructing charges, injuries to officers, and witnesses seeing Hopkins shove the victim. Even though he's young and inexperienced, the situation escalated far beyond what anyone would expect, forcing the court to scrutinize every action.
Just asking for some order that would allow him to work and just not have that kind of contact.
Response.
Your Honor, the bond in this case was set at $5,000 cash or surety when we requested a $50,000 bond. In this case, the people are uncomfortable with him being out. This was an event for a series of events that occurred where the defendant assaulted the victim at not one but two locations. An eyewitness saw the defendant shove the victim while near the police station. The police attempted to make contact with the defendant, and then he picked up, as a result of him resisting, picked up 5 counts of R&O against 4 different officers. One of those 5 counts is an R&O causing injury that was so severe that the officer is actually seeking specialized medical treatment from an orthopedic surgeon. At this point, this is a 9.
So hold on. There was a DV and then an officer injured. Why is he out?
Your Honor, if I could address.
Hold on. I'll let Ms. Barroso finish and then you can address it. I just had an intermediate question. Go ahead.
So at this point, I don't think that a modification of bond removing him from being on house arrest is appropriate. We objected to a nominal bond of $5,000 when it was originally granted. At this point, I don't think that any further reduction is appropriate.
A couple things. First of all, Mr. Hopkins is here with his father. He is 20 years old. He has no prior criminal history. In reviewing the police report and the video, even the report references that the altercation, that the incidents that resulted in this charge, that there were,
In which
that it was,
charge?
I'll start with the domestic violence. That with those charges, that there was a more complicated situation. I believe the officer said the report says something to the effect of, and this would also go to the property, that there had been physical altercations between the two of them, fighting between the two of them, and breaking of objects between the two of them. So I believe that there's more to this than said. The allegations of the domestic violence are the one of the shoving, and also I believe of Mr. Hopkins taking his own computer back from the complainant. That's the second allegation of the domestic violence. And the resisting and obstructing is, the allegations are that Mr. Hopkins, not that Mr. Hopkins turned around and slammed someone or punched them or anything, that he pulled away. The allegation is the officer fell and that caused the injury. And then that officer fell, yes, as he pulled away. And then subsequently, 4 officers who were, some of whom just pulled up on the scene in the video, all ran after him. And that's where the resisting and obstructing comes. And he did, in fact, eventually stop. It was not.
The judge grills both sides. Was a taser actually deployed? Were weapons drawn? Defense tries to downplay the events, claiming no punches occurred, emphasizing only minimal contact and routine police procedures. The prosecutor corrects him. Hopkins punched officers, twisted fingers, resisted arrest, ran from multiple officers, and required both a taser and a drawn firearm to stop him. The courtroom is almost shocked into silence as the judge tries to reconcile the conflicting accounts with what's visible on the video. Defense claims mitigating factors, prior domestic disputes, context of taking his own property, but the judge isn't convinced. Bond conditions hang in the balance as the court weighs public safety versus potential for rehabilitation. It's a clash of narrative, chaos versus justification.
It's not as if he were in a vehicle and went miles or hours away. He did stop running, and he did, once they complied, once that occurred, there were no further incidents. So,
Your Honor, I'm sorry, that is not the characterization of the RNO. The allegations include him punching 2 officers in the face, breaking free of their grasp, causing them to fall to the ground, twisting and seriously injuring an officer's finger. And then it went on for such a period of time that an officer had to point and deploy a taser. And that another officer had to point their pistol at a defendant. So at the defendant. So at this point, I don't think it was him passively.
Your Honor, I had an opportunity to view the video.
Well, you had an opportunity to view the video.
Yes.
Let me ask you this. Was a taser deployed?
Your Honor, when
I think that's either yes or no. Was a taser deployed?
Your Honor, as soon as the officer saw him, she pointed the taser at him. This is not, as soon as she saw him, she pointed the taser at him. This is not a situation where he was running and pointed the taser.
I didn't ask that, Ms. Gaines. I did not ask that.
Yes, sir.
Was the taser deployed?
Yes, it was.
Did an officer have to draw their weapon?
I did not see that. I could not see that on the video.
Ms. Burrows, are you indicating an officer had to draw their weapon?
That is what was indicated to me in the file, Your Honor. Yes.
And then there's an officer that's injured. Again, we'll ask the question. I don't know why this individual's out.
Again, Your Honor, he's 20 years old. He has no prior history, and he has no reason to come back to Washtenaw County other than for school in this case. It's my understanding. I have not heard any information that he has had any contact with the complainant, has violated any orders. He is just asking to be able to go to work and to be able to get a job and go to work. Your Honor, would you want to hear from Mr. Hopkins' father, who's present?
I don't know what he could tell me at this point in time. I'm more worried about the bond as it originally is set. Does he have prior convictions for anything?
No, Your Honor.
That the original domestic was about? I mean, I'm trying to figure out, because I'll just tell you, I have some serious concerns that this escalated to a point that officers are having to deploy a taser, pull their weapon. There are clearly enough officers around to, in my opinion, have subdued this individual without having to do all of that. So something else is going on. And
Your Honor,
I also have, I mean, one's bad enough, but I have 2 counts of domestic violence.
again, Your Honor, one of them is him taking back his own computer. That's one of the allegations. And that's why I'm saying there were things that were happening before this. That's not to excuse his behavior. That is to say that there's broader context. And in my view of the video, initially there was 1 officer, then there were 2, and he ran from 2, but as he's running from those 2, there are cars, 4 and 5 cars are pulling up with sirens on an unarmed young man who clearly panicked. This is not someone who's had police involvement, who has a history of contact with law enforcement and the criminal justice system. Again, I'm not excusing, but I do think that there is there's more. I think there are more nuances to this than the prosecutor does.
Well, explain some of those then. Because I've got a victim of a DV that's injured.
She is not, the domestic violence person is not injured. It was the shove and the taking of there's no injury to her.
Domestic violence are 2 misdemeanor counts.
That is
felonies here.
As the hearing continues, it becomes painfully clear. Judges respond to patterns, not excuses. Defense argues Hopkins has been compliant, only appearing in court for required dates, no new charges, no contact with the complainant. The prosecution paints a different story. 5 count of resisting and obstructing, assaults on officers, and escalating danger requiring tactical responses. The judge sits in the middle, balancing video evidence, witness accounts, and procedural rules while trying to filter confusion from fact. Every claim, every justification, every attempt to minimize the events is met with scrutiny. The tension peaks. This isn't about perfection. It's about compliance and accountability. The judge warns. One misstep, one mischaracterization of the facts, and the defendant risks losing bond entirely.
There are 5 counts of R, 5 counts.
Yeah, I see that.
Are no causing it.
Maybe I misread that on the report, but
Yes.
the injury to the fingers, that's the officer.
That's correct.
Thank you. I don't understand this. I mean, there's a lot I don't understand. How, and I get there are resisting and obstructings that are filed that some may look at as questionable in terms of the charge. I get that. But I'm also trying to figure out how an officer gets injured, that there are punches to the face of officers. I mean, Ms. Gaines, I don't get it.
I understand what you're saying, and I'm saying I did not see any punches to the face when I observed the video.
Tell you what, I'm certainly not changing any conditions. Can you explain to me one reason why I shouldn't raise his bond?
Your Honor, he has appeared for every court date, and he has not picked up any new charges. He has not had any contact with the complainant on the domestic violence or any of the officers. My understanding from him is that he has only come to Washtenaw County for court. He does not even reside in this county. It does not appear he's a flight risk, nor that he is a danger to the community. He is here with his father. He has come to every court date, and he's highly responsive to my calls and texts. And absent the no offer in this matter, we'd be looking to resolve it.
Anything else from the people?
No, Your Honor.
You know what? I'm not changing his condition in the bond. I'm not at this juncture gonna up his bond either, although of rights I should. Of rights, I don't think he should be out around tethered or not, given that behavior. But I'll let Judge Perry deal with that after she hears the preliminary examination. Bond will continue. Motion for bond reduction or changing condition is denied.
By the time this hearing comes to a close, one thing is painfully clear. The courtroom isn't reacting to excuses anymore, it's reacting to patterns. In both cases we just watched, the judges weren't looking for perfection, sympathy, or emotional speeches. They were looking for compliance, consistency, and accountability. And that's exactly where things fell apart. In the first case, the court is confronted with a young defendant whose situation escalated far beyond what anyone expects from someone with no prior criminal history. Domestic violence allegations, multiple resisting and obstructing charges, officers injured, a taser deployed, and even a firearm drawn. That combination alone is enough to make any judge pause. What really stands out isn't just the severity of the allegations, but the confusion and contradiction surrounding them. The defense repeatedly minimizes the conduct, while the prosecution paints a picture of chaos and danger. And the judge? He's stuck in the middle trying to reconcile what he sees on video with what he's being told in court. That's why the bond decision matters so much here. Bond isn't about guilt or innocence, it's about risk. Risk to the public, risk to alleged victims, and risk that the defendant won't follow court orders. And even though the judge openly states he has serious concerns and doesn't believe the defendant should be out at all, he ultimately holds the line. No reduction, no increase, just a warning hanging in the air that this situation could turn much worse if behavior doesn't change. It's the legal equivalent of being told, this is your last warning. Then we shift to the second case, and the tone changes completely. This isn't about violent escalation, it's about credibility. Bond violations, alleged tampering, positive alcohol readings, and most importantly, failure to follow direct court instructions. Judges take bond violations personally, because bond is built on trust. The court gives you freedom in exchange for compliance. Once that trust is broken, sympathy stops carrying weight. What seals the outcome here isn't just the alleged violations, it's the communication breakdown. Not turning yourself in when ordered, not clearly informing your attorney, letting the court scramble while excuses pile up afterward. At that point, the judge isn't evaluating circumstances anymore, he's evaluating reliability. And when reliability disappears, bond disappears with it. Revoking bond isn't punishment, it's control. It's the court stepping in to prevent further disregard for its authority. Taken together, these cases highlight something.
Finally, the gavel falls. After considering testimony, video, and arguments, the judge refuses to change bond conditions. Hopkins will remain on house arrest. His motions for reduction or modification are denied. The courtroom exhales. The judge makes it clear, bond isn't punishment. It's control, trust, and risk management. Courts tolerate mistakes, but punish patterns of unreliable behavior, not isolated missteps. Judges demand honesty, effort, and adherence to the rules above all else. The case closes as a cautionary tale. Young, inexperienced offenders can escalate situations beyond comprehension, and in the courtroom, patterns of chaos and noncompliance will always outweigh excuses. The warning hangs in the air. Change your behavior or the